I want to tell you about a Tuesday afternoon in March. I want to tell you about a man in a grey suit who sat across a conference table from me, looked me directly in the eyes, and told me something that was not true, not a misunderstanding, not a difference of opinion, a deliberate, calculated, professionally delivered lie. And I want to tell you that I had my phone in my jacket pocket the entire time, recording. By the end of this video, you are going to hear exactly what he said. You are going to hear what happened when his own words were played back to his company's legal department. And you are going to understand why I will never again walk into a room with an insurance company representative without that recording light blinking red. My name is Ray Callahan. I am 51 years old. I own a landscaping business in Baton Rouge, Louisiana. I have never been arrested. I have never missed a mortgage payment. I have been driving for 33 years without a single at-fault accident. And for 61 days, an insurance adjuster named Dennis Pruitt told anyone who would listen that I had caused a crash that put me in a neck brace and destroyed my truck. He was wrong. He knew he was wrong. And I can prove it because I recorded every single word he said. March 12th started the way most Tuesdays start for me. I was up at 5:30, made coffee, dark roast, no sugar, same as every morning for 20 years. Fed my dog, a 7-year-old black lab named Roosevelt, who believes with his whole heart that 5:30 a.m. is an unreasonable hour for any living creature to be conscious. Checked the weather, clear skies, light wind, perfect for the 3 residential landscaping jobs we had booked. I run Callahan Outdoor Services with my son Marcus, who is 26 and works harder than any employee I have ever had. We have 8 crew members, 2 commercial mowers, a 4-trailer setup, and a client list we've built over 14 years of showing up on time and doing exactly what we said we would do. It's not glamorous work, it is honest work, and there is not a single day I have been ashamed of it. My truck, a 2020 Ford F250 Super Duty in dark bronze, was as much a part of the business as the mowers. I bought her new, paid her off in 3 years. She had 61,000 miles on her, every single one of them earned. Trailer hitch rated at 18,000 pounds. Bedliner I'd had sprayed on before the first trailer was ever hitched. She was clean. She was maintained. She was mine. I mention all of this because I need you to understand who Ray Callahan is before I tell you what happened to him. I need you to know that I am not a man who exaggerates. I am not a man who looks for problems. I am not a man who causes scenes or makes accusations without evidence. I am the kind of man who records his conversations. Not because I am paranoid, because 14 years of running a small business has taught me that the most important thing anyone ever says to you is the thing they will later claim they never said. That habit, that quiet, boring, totally mundane habit of pressing record before I answered my phone, is the reason I am sitting here today instead of having accepted a settlement that was a fraction of what I was owed. But I'm getting ahead of myself. March 12th, 4:47 p.m. We had finished the last job of the day, a residential account on Perkins Road, clean cut, edge work, mulch refresh on the front beds. Good crew, good day. Marcus was driving the trailer rig back to our yard. I was in the F250 heading home to pick up my wife Linda for a dinner reservation at a place on the river we'd been trying to get into for 2 months. The reservation was at 7. I had time. I was not rushing. I had the radio on, country, which Linda pretends to hate, but knows every word to, and I was thinking about whether to order the redfish or the ribeye. I turned onto Airline Highway northbound at 4:51 p.m. I know the exact time because I glanced at the dash clock when my phone buzzed. Marcus, asking if I wanted him to park the trailer at the yard or at the job site for tomorrow. I sent a voice message back, park it at the yard, and put the phone on the seat. I did not look at my phone again. 4 minutes later, at 4:55 p.m., I was at the intersection of Airline Highway and Stumberg Lane, and the next 12 seconds are the ones that changed everything. Here is what I remember, and here is what I have been told by people who were trained to analyze these things. The light at Stumberg had been green for northbound airline traffic for approximately 9 seconds when I entered the intersection. I was traveling at 38 miles per hour. The speed limit was 40. I had the cruise control set. I was not on my phone. I was not distracted. I was in the right lane of a 3-lane divided highway in broad afternoon daylight with clear visibility in all directions. From the left, from the Stumberg Lane approach to the intersection, a 2019 Chevrolet Tahoe came through. The driver was a woman named Cheryl Ann Fontenot, 44 years old. She was the regional manager of a medical supply company. She was on a Bluetooth call. She ran a red light that had been red for approximately 7 seconds. 7 seconds. At the speed she was traveling, later estimated at 51 miles per hour in a 35 zone, she had been on a red light from before she even reached the intersection. There was no ambiguity. There was no yellow light debate. There was no he said, she said about whether it had just changed. That light was red and had been red long enough that the cross traffic was already moving. The Tahoe hit my F250 on the front driver's side, not a glancing blow. A direct, high-speed, perpendicular strike. Both airbags deployed. The driver's side door intruded approximately 8 inches into the cab. The A-pillar cracked. The windshield shattered inward on the driver's side. The engine was pushed back toward the firewall. I remember the sound, not the impact. The impact was too fast for my brain to register as a separate event. What I remember is what came after. A sound like the world had rearranged itself, a high-pitched ringing, the chemical smell of the airbag propellant, the sudden weight of silence where the radio had been. I tried to open the door. It didn't move. I sat for what felt like a long time, but was probably 15 seconds trying to understand what had happened to my truck. Roosevelt wasn't with me. He stays home on Tuesdays. That was the first coherent thought I had. Thank God the dog is home. The second coherent thought was, my phone is recording. Not an accident, not a coincidence. I had a habit. Every time I got a voice message while driving, I dictated a reply and put the phone face down on the seat with the voice memo app still open from a habit I had developed over years of documenting job site conversations. The app records continuously until you close it. My phone had been recording since the moment I picked it up to send Marcus that message. It had recorded the radio, it had recorded the highway noise, and it had recorded 12 seconds of screaming tires and impact and silence that would become the most important audio file I would ever possess. I didn't know that yet. I just knew the phone was on the seat and I needed to secure it before anything else. I reached over. The phone was on the floor, having slid during the impact. Screen cracked in the corner, but still on. Voice memo still running. I picked it up and ended the recording. I had 43 minutes of continuous audio that ended with a car accident. I put the phone in my chest pocket and zipped it. Then I tried to open the door again. This time it gave, barely grinding, and I stepped out onto Airline Highway. My neck was wrong. I knew it immediately. Not broken. I could move. But something was compressed or inflamed or simply very angry about what had just happened to it. My left wrist had taken the impact of the steering wheel through the airbag. My left ear was ringing so badly I thought for a moment I might have lost some hearing. I was standing in the middle of a highway, somehow standing, looking at my truck. The front driver's corner was destroyed. The hood was buckled upward at an angle. The left front wheel was gone, not damaged, gone, sheared off, and 20 feet away in the center median. Glass across both lanes. Fluids on the asphalt. She was gone. My F250 was gone. The Tahoe had come to rest against the concrete median barrier. Driver's side deployed airbags, front end compressed. The driver was sitting inside, head down. Her Bluetooth call had presumably ended. First responders arrived within 4 minutes. Police, fire, EMS, standard Baton Rouge response time on a major arterial road. And then, and this is the part I need you to pay close attention to, one of the first things that happened after the police arrived was that a man in a gray sedan parked behind the police perimeter got out and walked directly to Cheryl Fontenot. He was not a paramedic. He was not a police officer. He was not a firefighter. He was, I would later discover, a claims representative from River State Insurance Company, Cheryl Fontenot's insurance company. He was at the scene within 12 minutes of the accident. Think about that. 12 minutes on a Tuesday afternoon at an intersection on Airline Highway. Insurance companies have field adjusters whose job is to respond to significant accident scenes before the scene is cleared, before statements are taken, before the involved parties have spoken to an attorney or processed what has happened to them. This is not illegal. It is, however, something that most accident victims do not know is happening. His name, I would later learn, was Dennis Pruitt. And from that moment at the scene, from that very first moment, Dennis Pruitt was not there to find the truth. He was there to manage it. The EMS crew put me in a neck brace on the scene. They wanted to transport me, but I declined, which I should not have done, and I will come back to that, and signed a refusal of transport. My wife, Linda, arrived within 20 minutes, having gotten a call from Marcus, who had somehow heard through the scanner app he keeps on his phone for exactly this kind of paranoid reason. Bless him for that. A police officer named Sergeant David Bourgeois took my statement at the scene. I told him everything. Green light on airline. I was in cruise control at 38. The Tahoe came from my left. I never saw her until the moment of impact. He wrote it down. Then he took Cheryl Fontenot's statement. I was not present for her statement. I was sitting on the bumper of a fire truck getting my blood pressure checked. But what I was told later, by the official police report, was that Cheryl Fontenot told Sergeant Bourgeois that my truck had run a red light on Airline Highway and that she had entered the intersection on green. She said, I ran the red. I had been at a green light for 9 seconds. My cruise control was set at 38. I was heading home for a dinner reservation thinking about redfish versus ribeye. And she said, I ran the red. Linda was there when I got the news from Sergeant Bourgeois. I remember her hand tightening on my arm. I remember being too tired and too much in pain to have the reaction I would normally have had. I just said to the sergeant, "I have audio from inside my vehicle. I had my phone recording." Bourgeois wrote that down. Dennis Pruitt, standing 30 feet away, also heard me say it. I watched him walk to his grey sedan, get in, and make a phone call. The thing about insurance field adjusters is that they are not investigators in any meaningful sense. They are not licensed investigators. They do not have subpoena power. They cannot compel anyone to speak with them. What they have is presence and timing. They arrive early, they seem official, and they speak to people who do not yet know what their rights are. Cheryl Fontenot had an insurance representative at her elbow within 12 minutes of the crash. I had nobody. I had Linda, who was wonderful, and Marcus, who arrived 30 minutes later and immediately started taking photographs of everything. God bless that boy. But I had no professional advocate of any kind. That asymmetry, that 12-minute head start, is the insurance industry's oldest and most effective tool. I didn't fully understand it yet, but I was about to get a very thorough education. Linda drove me to Our Lady of the Lake Regional that evening. The diagnosis: cervical strain with moderate soft tissue involvement, contused left wrist, mild concussion, bilateral tinnitus, likely related to airbag deployment. I was given a prescription anti-inflammatory, a cervical collar, and a referral to a specialist for the wrist. The ER physician told me to follow up within 5 days. The discharge paperwork time-stamped me, leaving at 9:14 p.m. Linda and I never made our dinner reservation. He called at 8:47 the next morning. I need to tell you something about how I answered that call. I had my phone in my hand when it rang. Unknown number, Louisiana area code. I looked at Linda across the kitchen table. She looked at me. And without saying a word to each other, I opened my voice memo app, started a new recording, set the phone face up on the table, and then answered on speaker. 14 years of small business ownership. The voice was smooth, professional, the kind of voice that has been trained to sound like it is on your side. "Mr. Callahan, this is Dennis Pruitt. I'm a senior claims representative with River State Insurance. I'm reaching out as a courtesy to discuss the incident that occurred yesterday afternoon on Airline Highway. Do you have a few minutes?" Courtesy. He said courtesy. I said yes. He said he was sorry to hear about my accident. He said River State took these matters very seriously. He said they were conducting a thorough investigation. Then he said, "At this early stage of our review, based on the preliminary statements we've received, our assessment is that the signal situation at the intersection may be somewhat complex. We're going to need some time to fully evaluate all the factors involved." Complex. He said the signal situation was complex. I said, "The light was green for me, Mr. Pruitt. I had cruise control set at 38 miles per hour. I've been driving that road for 15 years. He said, "I understand, Mr. Callahan, and we want to make sure your perspective is fully represented in our assessment. I do want to mention, and I'm sharing this as a professional courtesy, that in situations like this, where there are conflicting accounts, things can become quite complicated from a liability standpoint. I'd hate for you to find yourself in a difficult position." There it is, right there, in that sentence, right there in the second phone call of my claim. He wasn't investigating, he was warning me. He was using corporate language to tell me gently that I was about to be blamed for this accident, and that my options were to accept it quietly or face something more difficult. He did not know I had it on tape. I said, "I appreciate the information, Mr. Pruitt. I'll be in touch." I ended the call. I saved the recording. I labeled it Pruitt Call 1, March 13th. Linda said, "Call an attorney." She was right. She is almost always right. Her name was Grace Thibodeau, and she had been practicing personal injury and insurance litigation in Louisiana for 23 years. Her office was on 3rd Street in Baton Rouge, in an older building with a waiting room that had a coffee machine that actually worked, and a paralegal named Vincent, who had been with her for 16 years and had the quiet efficiency of a man who had seen every version of every insurance dispute and was no longer surprised by any of them. I sat across from Grace Thibodeau on the morning of day 20. I had my legal pad, I had my printed phone logs, I had my cloud storage folder with 22 audio recordings, I had the police report, I had the denial letter, I had the ER records and the specialist records and the imaging reports. I had the truck valuation comparables Marcus had printed for me. I had, in short, everything. Grace Thibodeau did not touch any of it for the first 10 minutes. She just listened to me talk. No notes, no laptop, just listening. When I finished, she said, "Play me call 11." I played her call 11. Dennis Pruitt's voice, saying nothing to suggest your account of the incident is inaccurate. 8 days before the denial. Grace Thibodeau was quiet for about 15 seconds. Then she said, "How many total recordings do you have?" I said 22. She said, "When did you start recording?" I said the second call, the morning after the accident. She looked at me for a moment. Then she said, "Mr. Callahan, in my 23 years of practice, I have had clients bring me dashcam footage, cell phone photos, witness videos, and written statements. I have never had a client walk in with 22 recorded conversations with the opposing adjuster, including one in which he specifically contradicted the denial letter 8 days before it was written." I said, "Is that good?" She almost smiled. Not quite, but almost. She said, "That's not just good. That is potentially a textbook insurance bad faith case. Louisiana has some of the strongest bad faith insurance statutes in the country. Under Louisiana Revised Statute 22:1973 and 22:1892, an insurer who arbitrarily and capriciously denies a valid claim or who makes a misrepresentation to a claimant can be held liable for the claim amount plus penalties of up to 50% of the claim and attorney fees. What you've described, an adjuster verbally assuring you your account was credible while the denial letter was already being drafted, is a textbook misrepresentation." I said, "And the recording proves he said it." She said, "The recording proves he said it." She picked up a pen. "Let's talk about what happens next." Grace Thibodeau moved quickly. Within 72 hours of retaining her, 3 things had happened. First, she sent letters of representation to River State Insurance, to my own carrier, Southern Shield Insurance, and to Cheryl Fontenot's personal attorney if she had one. She did. A man named Arsenault, who apparently did a significant amount of work for River State as defense counsel. Second, she filed a preservation demand, a formal legal notice requiring River State to preserve all internal communications, claim notes, adjuster records, supervisor correspondence, and any other documentation related to my claim. Under Louisiana law, failure to preserve those records after a preservation demand can be treated as evidence destruction in subsequent litigation. Third, she hired an audio forensic specialist named Carl Dempsey, a former FBI technical analyst who now worked as a private consultant, to conduct a professional enhancement and authentication of my 22 recordings. This was important because River State's defense would almost certainly challenge the admissibility and authenticity of the recordings if the case proceeded to litigation. Carl Dempsey's report, delivered on day 31, was 11 pages long and contained several findings that Grace described to me over the phone as extremely helpful. The most significant finding was this: the voice on call 11, the call in which Dennis Pruitt told me nothing to suggest your account is inaccurate, was confirmed through voice pattern analysis to be the same speaker as the voice on all other recorded calls identified as Dennis Pruitt. There was no question of who had made the statement. The authentication was unambiguous. The second significant finding involved something I had not even considered. Call 1, the very first call on March 13th, had captured background noise, normal background noise, office sounds, and nested within that background noise, at several points during the call, Carl Dempsey had identified what appeared to be fragments of a separate conversation happening near Dennis Pruitt's desk. At 4 minutes and 22 seconds into call 1, a voice, not Pruitt's, said something that Dempsey had enhanced and partially reconstructed as Fontenot file, signal was, need to get ahead of. At 6 minutes and 41 seconds, the same or similar voice said something containing the words, liability exposure if it goes the other way. These fragments were not conclusive on their own. They were ambient, partial. A defense attorney would argue they were ambiguous, but in the context of the full picture, the timing of the denial, the contradiction in call 11, the field adjuster at the scene within 12 minutes, they painted a picture of an organization that had decided its position before the investigation was complete. Grace said, they made a decision early, probably within the first 24 to 48 hours. And then Dennis Pruitt spent 30 days managing you toward that outcome while telling you the opposite. I said, that's what I thought was happening. She said, it's what was happening, and you recorded all of it. She filed suit on day 35. And now I need to tell you about the Tuesday afternoon in March that I mentioned at the very beginning of this video. The conference room, the man in the gray suit, the recording light blinking red in my jacket pocket. It was day 43. River State's attorneys had requested a meeting, not a formal deposition, not a mediation, an informal settlement conference, their words, at their offices on Jefferson Highway. Grace told me we didn't have to go, that it was likely a fishing expedition to assess what we had, but that she thought it might be useful to see how they positioned themselves now that they knew about the recordings. I said I wanted to go. She said, if you go, you say almost nothing. You let me talk. The only thing you do is listen and remember. I said, I understood. She said, and Ray, she almost never used my first name. Don't tell them what's on those recordings, not all of it. Let them wonder. I said, I understood that too. But what I didn't tell Grace, what I did in the parking garage of the River State building on Jefferson Highway 45 seconds before we walked into the elevator, was that I opened my voice memo app and pressed record, and put the phone in my inside jacket pocket with the microphone facing outward through the fabric. Old habit. The conference room was on the 4th floor, corporate, clean. The kind of room with a long table and generic landscape art, and a coffee and water station in the corner that nobody uses because accepting hospitality from opposing counsel feels like the first step toward conceding something. Dennis Pruitt was already there. This was the first time I had seen him in person since the accident scene on March 12th, since I had watched him walk to his sedan and make that phone call. He was 50-something, heavy-set, in a well-fitted grey suit, silver tie, the kind of man who had been doing this for a long time and had made peace with what doing it required. He did not offer his hand. He nodded. Beside him was River State's in-house counsel, a woman named Sandra Cole, who had the focused, economical manner of someone accustomed to being the most prepared person in any room. Beside Sandra Cole was another man I didn't recognize, who was introduced simply as a representative from River State's Claims Management Division. He didn't give his last name. I noticed Grace write something on her notepad and underline it. We sat down. Sandra Cole opened by saying River State had reviewed our filing and believed there were several factual issues that warranted discussion before the matter proceeded further. She said River State remained committed to a fair resolution for all parties. She said they were open to a dialogue. Grace said, "We appreciate that. Why don't you tell us what River State's current position is on liability?" Sandra Cole said their current position was that liability remained a contested factual question and that River State maintained its initial determination pending further investigation. Grace said, "Further investigation. The accident was 43 days ago. What investigation is ongoing?" Sandra Cole said they were working to obtain additional witness statements. Grace said, "From whom?" The police report lists 3 civilian witnesses. All 3 have already provided statements. All 3 corroborate Mr. Callahan's account. Which witness are you still pursuing? Sandra Cole looked at Dennis Pruitt, and Dennis Pruitt said something. He said, and I have this on tape, and Grace has confirmed it is admissible in Louisiana, and River State's own legal department has since heard it. He said, "Ms. Thibodeau, I want to be straightforward with you. Our position has always been that this was a complex intersection event. I think if you look at what we communicated to Mr. Callahan during our conversations, you'll find we were very careful never to validate his account of the signal status. We were consistently clear that the investigation was ongoing and that no determination had been made. Very careful never to validate his account. Consistently clear that no determination had been made. The phone was in my jacket pocket. The red light was blinking, and Dennis Pruitt had just told the attorney for the plaintiff, on the record, in a conference room, the exact opposite of what he had told me on March 28th. I looked at Grace. She was writing something on her notepad. She did not look up. She said, "Mr. Pruitt, when you say you were careful never to validate Mr. Callahan's account, can you confirm that is consistent with all communications you had with him throughout the claims process?" Pruitt said, "Absolutely. That is our standard protocol. We don't make liability assessments in verbal communications with claimants." Grace wrote something else. She said, "Thank you. I think we have what we need for today." Sandra Cole said, "I'm sorry, we've barely begun. We had hoped to discuss a potential framework for resolution." Grace said, "I understand, but I think before any framework is productive, you'll want to review some materials I'll be sending over this afternoon. After you've had a chance to review them, we can schedule another conversation." We stood up, shook hands, or didn't. Dennis Pruitt did not shake my hand. He nodded again. The same nod as when we walked in. Controlled, professional. In the elevator going down, I said nothing. In the parking garage, I said nothing. When we reached Grace's car, I took out my phone and stopped the recording. Grace looked at it. She said, "Did you just record that meeting?" I said, "Old habit." She closed her eyes for 3 seconds. Then she said, "Louisiana is a one-party consent state. You were a party to that conversation. The recording is legal." I said, "I know." She said, "Ray?" I said, "Yes." She said, "He just told us, on tape, the complete opposite of what he told you on March 28th. I said, "I know." She said, "I'm going to need a copy of both recordings." Grace sent the materials on day 44. Not all 22 recordings. Not yet. She sent 3, strategically chosen, clearly labeled. Recording 1. Call 11, March 28th. Dennis Pruitt's voice saying nothing to suggest your account of the incident is inaccurate. 8 days before the denial letter. Recording 2. The conference room meeting. Day 43. Dennis Pruitt's voice saying we were very careful never to validate his account of the signal status. Recording 3. Call 1, March 13th. 43 minutes of vehicle audio, beginning when I dictated the voice message to Marcus, continuing through the intersection, capturing the screeching tires, the impact, and the aftermath. Timestamp confirmed by phone metadata. Speed and location data corroborated by the vehicle's OBD port data that Marcus had downloaded from the truck's computer before it was crushed. The OBD data showed 38 miles per hour. Throttle at cruise control setting. Brake not applied before impact. Consistent with everything I had said from the first moment. Grace included with the recordings a brief cover letter to Sandra Cole that said, in its entirety, "Please find attached 3 audio files relevant to the above referenced matter. We would welcome a call at your earliest convenience." She told me afterward. I almost felt bad about it. Almost. She heard from Sandra Cole in 4 hours. The call lasted 11 minutes. Grace took it in her office with Vincent on a second extension taking notes. She told me about it that evening. Sandra Cole had said, in various formulations, 4 things. 1. She had not been aware of the content of the attached recordings prior to today. 2. River State was concerned that Mr. Pruitt's communications with the claimant may not have fully adhered to company protocol. 3. River State would be conducting an internal review of the handling of this claim. 4. River State was prepared to discuss a comprehensive resolution and would appreciate a meeting at the earliest mutually convenient time. Grace had said, "We're available Thursday." Sandra Cole had said, "Thursday works." I want to explain something about what happened in those 4 hours between when Grace sent the recordings and when Sandra Cole called back. I don't have complete information about what happened inside River State's offices. I have some information from what emerged in subsequent discovery, and I have Grace's professional assessment of what almost certainly occurred. What almost certainly occurred is this. Sandra Cole played the recordings for River State's legal team. The legal team identified the direct contradiction between Call 11 and the conference room statement. They identified the vehicle audio corroborating my account. They ran a quick analysis of their exposure under Louisiana's bad faith insurance statutes. Under Louisiana RS 22-1973, an insurer who arbitrarily and capriciously fails to pay a claim within 60 days of receiving satisfactory proof of loss is subject to penalties of twice the damages sustained or $5,000, whichever is greater, plus attorney fees. We were now on day 44. Under Louisiana RS 22-1892, a 10% penalty applies to the amount due for arbitrary failure to pay within 30 days, and those penalties were before any punitive exposure for the misrepresentation itself, which, depending on how aggressively Grace wanted to pursue it and what emerged in discovery, could be substantial. Someone in River State's legal department did that math. And then they called Sandra Cole, and Sandra Cole called Grace. I don't know what Dennis Pruitt was told that afternoon. I know he was not at the Thursday meeting. I am not going to tell you the specific dollar amount of the settlement. It is confidential under the terms of the agreement, and I intend to honor that. What I can tell you is this. The settlement fully compensated me for the replacement value of my F250, not the $38,400 my own carrier had offered me. The actual market replacement value supported by comparable listings, which Grace had documented and submitted. The settlement fully compensated me for my medical expenses, the ER, the cervical specialist, the wrist imaging, the orthopedic follow-up, the physical therapy that began on day 28 and would continue for another 4 months. The settlement compensated me for lost business income. Marcus and I had documented, carefully and completely, the jobs we had declined or been unable to complete during the period of my reduced capacity. Louisiana law allows for loss of earning capacity as a recoverable damage in personal injury matters. Grace knew exactly how to document and present those figures. The settlement included a component related to the bad faith handling of the claim, the delays, the misrepresentations, the contradiction between what Dennis Pruitt told me and what the denial letter said, that I am not permitted to discuss in specific terms, but that Grace described to me at the signing as appropriate given the conduct. And the settlement included something that I had not expected and had not asked for, but that Grace had negotiated quietly and told me about only when the documents were ready to sign. River State agreed, as part of the terms, to conduct a mandatory claims handling review of the Dennis Pruitt file and all claims he had handled in the previous 2 years. This review was to be conducted by an independent auditor mutually agreed upon by both parties. Grace had inserted this clause not because it affected my compensation, but because, as she put it to me, if he did this to you, he did it to other people, and those people deserve to know. I signed on day 61. I shook Grace's hand. I shook Vincent's hand. I sat in my car in the parking garage and called Linda and said, "It's done." She said, "How much?" I said, "Enough." She was quiet for a moment. Then she said, "Come home. I want to talk to you directly for a few minutes, not as a story, as a conversation. I have been driving vehicles in Louisiana for 33 years. I have been running a business for 14. I have signed contracts, negotiated with suppliers, dealt with difficult clients, managed employees, and navigated every ordinary form of conflict that comes with being a working adult in America. I was completely unprepared for what happened after that accident, not because I was naive, not because I was unintelligent, but because the insurance claims process is specifically designed to look like something it isn't. It is designed to look like a neutral investigation conducted by professionals who are trying to determine what actually happened, what it actually is. In too many cases, and I want to be fair and say not all cases, is a managed outcome process in which a decision is made early and the subsequent investigation is the architecture built to support that decision. Dennis Pruitt decided something in the first 48 hours, probably in the first 24, and then for 30 days he managed me, calling regularly, sounding reasonable, expressing concern, offering reassurance, while the denial letter was being drafted. He was good at it. If I hadn't been recording those calls, I would have had no evidence of the contradiction. I would have had my word against his about what he'd told me, and against a senior claims representative with 20 years of experience and a corporation's legal team behind him. My word alone would not have been enough. The recording changed everything, not because it was dramatic, not because it exposed some shocking secret, but because it simply captured the truth of what was said, in the moment it was said, without any possibility of revision or reinterpretation. That is all a recording does. It holds the truth in place. So here is what I want you to take from my story. First, know your state's recording laws before you need them. Second, start recording from the very first contact. Third, document everything in writing after every call. Fourth, never give a recorded statement to the opposing insurance company without an attorney. Fifth, the denial is not the end. It is the beginning. Sixth, get an attorney before you need one. Seventh, record your calls. Record your meetings. Record everything. If you like this story, please like this video, share it with your friends, and don't forget to subscribe.